Good afternoon. Thank you for joining me today. I'm Shelley Lee Griffin, an executive partner at the law firm Secrest Wardle at its Troy location. I've been practicing law for more than 25 years, specializing in property insurance coverage disputes, litigation, and subrogation matters. This is the second webinar and podcast by Secrest Wardle's COVID-19 Task Force. If you missed our prior podcast, which was presented by Henry Emmerich on September 16th, you can find that on our website. It was a fantastic webinar and presentation as Henry discussed the country's first ruling in the insurance industry's favor in a case that he handled, Gavrilides versus Michigan Insurance Company. He also talked about business interruption claims in general, the legal rationale surrounding virus exclusions, and offered a number of practice tips. Today we're going to look at the COVID-19 business interruption claims, specifically the legal trends and developments that have occurred so far since this global pandemic occurred. We'll begin by looking at a timeline of the coronavirus, and then we will look at reactions to the pandemic, first by legislators and then by policyholders and insurers in the form of litigation. We will look at the trends that we've noticed in the early months of the litigation, including the class actions that have been filed and efforts to consolidate or centralize litigation. Lastly, we'll look at the legal developments based on a number of rulings and motions to dismiss that have been issued by state and federal courts related to the business interruption claims so far. So let's begin. Let's begin with a quick review of the COVID timeline. So much has happened that it's hard to believe that less than 12 months ago, most of us had never heard of the coronavirus. The first time most of us heard of the coronavirus was in December of 2019, which is when the world first learned about a mysterious flu that was originating out of China. By January 2020, the U.S. had seen its first confirmed case in California. By February, travel restrictions were being ordered and those continued to escalate. And by March of 2020, the country declared the coronavirus pandemic a national emergency. That same month, residents were being ordered to stay at home except to go to work if they performed an essential job function and for the purpose of shopping. But most residents were encouraged and ordered to stay home otherwise. Other states followed with similar orders. In fact, Michigan's stay-at-home order was first issued on March 24, 2020. By then, we had already seen the first lawsuit filed disputing the business interruption insurance coverage in the case of Oceana Grill versus Lloyd's of London, which was filed in Louisiana. Still in the month of March, we saw the first legislative bill for retroactive expansion of business interruption coverage that was filed in the state of New Jersey. Other states followed, including Michigan, had its own proposed legislation by April of 2020, which brings us to September 2020, where there are several state legislation proposals and federal legislation proposals pending related to business interruption coverage, and there is a total of 1,229 cases pending stemming from the business interruption claims related to COVID-19. The reason I put this in a timeline is to illustrate the point that we are still in the early days. Medical experts have no idea what the future holds in terms of containing COVID-19, and the ripple effect for businesses and insurance companies has a potentially quite significant and will be felt for a long time. The information in this space changes daily. No doubt we'll have to revisit this matter again in the future, at which time I will share a deeper dive with you. But for today's presentation, we're going to cover the basics and look at what do we know now. With the global pandemic, we've seen a significant rise in legislative proposals related to business interruption coverage. 2 federal bills have been introduced. The first is the Business Interruption Act that was introduced on June 29, 2020. The second bill was the Pandemic Risk Insurance Act, introduced August 4, 2020. According to the governmenttrack.us website, which predicts the likelihood of bills being enacted, the Business Interruption Act is predicted to have a 1% chance of being enacted and the Pandemic Risk Insurance Act, introduced this summer, has a 2% chance of being enacted. Several state legislators reacted to the shutdown orders and its impact on its constituents by introducing bills to address business owners' loss of income from the pandemic. Significantly, the policies that the business owners and the legislators were seeking to enforce coverage were never written for a global pandemic like the one that we are experiencing now. Nevertheless, these proposed bills wanted to mandate business interruption coverage. They also wanted there to be retroactive application for business interruption coverage, in most cases stemming from when the first shutdown orders were issued by their local governments. Some of the proposals have included the potential for a fund which would allow insurers to recover some of the payments made to the business owners. However, this was a significant problem because the policies were never written to cover the pandemic. And more importantly, premiums were never collected for such a risk. These proposed bills have mostly stalled as they faced significant constitutional challenges, which barred insurance companies from the right to contract. California has taken a different approach in an attempt to avoid any constitutional challenges. They've introduced Assembly Bill 1552, which has also been submitted as a revised version. The bill would create a rebuttable presumption that COVID-19 was present on the insured's property and that it caused physical damage to the property, which was the direct cause of the business interruption. This presumption would shift the burden of proof to the insurer, meaning the insurance company would have to prove that COVID-19 was not present and did not physically damage the business owner's property. Because this is a rule of evidence rather than a rule of substantive law, it has been argued that it is more likely to pass constitutional scrutiny. The next area that we want to discuss is the mounting number of cases stemming from denials of coverage from business owners seeking business interruption coverage. After many businesses were forced to close based on the shutdown orders, they submitted claims to their insurance carrier seeking business interruption coverage. The gist was that these executive orders were forcing their businesses to shut down, and at the time, these shutdown orders were put in place in order to flatten the curve of the spread of the coronavirus. Nevertheless, it had the consequence of having business owners close their businesses. In most cases, they were not allowed to use their businesses and were seeking to recover that loss of income. Many business owners, after receiving denial letters denying coverage, filed suit for breach of contract. The suits have included demands for payment under the business interruption coverage, the extra expense coverage, and the civil authority coverage. This included lawsuits involving all risk policies, named peril policies, some policies with a virus exclusion and some without. Historically, business interruption coverage requires direct physical loss or damage. This has been seen in lots of instances where businesses have been damaged by fire, water, weather event, or a natural disaster in which the insured property is physically damaged and the business can no longer operate. Sometimes there's business interruption coverage based on civil authority where there's damage to a nearby property, not the insured property that's been affected and physically damaged by fire, flood, or some other disaster. The business interruption coverage stemming from COVID was arguing in an unprecedented manner that coverage was required based on the global pandemic. In some instances, it may have been that the shutdown order required the business to close. In some cases, it was argued that employees or customers inside the business actually had contracted the virus and the virus was present within the insured location. This next slide is a chart which I copied from the COVID coverage litigation track, which is information that has been collected and the site created by Professor Tom Baker of the University of Pennsylvania Law School. This chart shows the business interruption suits at a federal level that have been filed since 2009 to 2020. If you notice, the blue line on the graph shows lawsuits that have been filed in the last 11 years. There have been noticeable peaks in those business interruption filings associated with natural disasters. For example, if you look at the peaks around 2009 and 2010, the increased number of suits, which did not reach 150 during 2009, were the result of Hurricane Ike. There was another peak in business interruption filings around Superstorm Sandy in 2014. And then in 2018 and 2019, we see peaks again as a result of Hurricanes Irma and Harvey. What's interesting to note about this particular graph is that it was last updated around July 20th, 2020, more than 2 months ago. It showed at that time the number of business interruption suits stemming from COVID-19 to be around 500. As we already covered, we know that number has nearly doubled. But what this highlights is that not only are we interpreting coverage in an entirely new context, but more importantly, we're dealing with unprecedented numbers of cases with the implications to be quite profound. The COVID coverage litigation tracker shows as of September 28, 2020, that more than 1,000 lawsuits have been filed. In these suits, by policyholders are seeking most frequently to enforce business interruption or business income coverage. Next, they're also seeking extra expense and then enforcement of the civil authority coverage. And in some instances, as the graph shows, they're requesting all three. One of the first trends that we noticed in the litigation was that 1/3 of these cases have been filed as class actions. So the number of lawsuits do not nearly reflect the number of policyholders and business holders that are actually seeking coverage. The next slide shows a breakdown by category of where these class actions have been filed. The majority of them have been filed in federal courts, but there is still a significant number that does not involve class actions. The second litigation trend has been an effort to have the COVID-19 business interruption litigation consolidated or centralized. We first saw this by the U.S. panel for multi-district litigation. The movement to centralize the federal litigation before the multi-district litigation panel began by the filing of 2 petitions where the policyholder sought creation of a national multi-district litigation in one of 2 jurisdictions. In order for consolidation to be allowed, the petitioners were required to show that there was a common question of fact for centralization. Ultimately, the petitioners would not be allowed to centralize the federal litigation because it did not serve the convenience of the parties and there was not enough common questions of facts being advanced. The court issued a ruling on August 12, 2020, after hearing oral arguments from many interested parties. More than a dozen attorneys presented arguments during the hearing on the consolidation. In its ruling, the multi-district litigation panel stated, put simply, the MDL that movements request entails very few common questions of fact, which are outweighed by the substantial convenience and efficiency challenges posed by managing a litigation involving the entire insurance industry. The proponents' arguments that these problems can be overcome are not persuasive. We therefore deny the motions for centralization. The panel also refused alternatives that have been proposed by other policyholders. That was that there be centralization based on region or centralization based on a state-by-state basis. What was interesting, though, is that the August 20 order required 4 insurers to show cause why actions against each of them should not be centralized. Those 4 insurers were certain underwriters at Lloyd's of London, Cincinnati Insurance Company, Hartford, and Society Insurance. The panel indicated that the actions against these 4 insurers are more likely to involve insurance policies utilizing the same language, endorsements and exclusions, Thus, there is a significant possibility that the actions share common discovery and pretrial motion practice. Moreover, centralization of these actions could eliminate inconsistent pretrial rulings with respect to the overlapping national class claims that most of the insurers face. Hearings were held last week on the question of whether these 4 insurers' actions should be consolidated. The counsel for and against echoed the previous arguments that were set forth in the original consolidation efforts. In either event, it's not clear how the panel will address the differing state laws if this does occur. A ruling is expected in the next few weeks. Although federal consolidation efforts were unsuccessful, at least one state was able to successfully consolidate all actions. In July, an Allegheny County court within Pennsylvania ruled that all claims involving Erie Insurance Exchange would be consolidated and heard by a single court. At the time, there was only 3 lawsuits pending in the state of Pennsylvania against Erie, but the court's ruling in that case required that Erie notify it of any similar actions so that those matters can also be transferred. Next, we look at efforts by the insurance companies to dismiss the business interruption cases filed against them. Motions to dismiss or motions for summary disposition have been filed with courts to determine if the COVID-19 business interruption claims are viable causes of action. According to the COVID Coverage Litigation Tracker, as of September 28, 2020, 254 motions to dismiss were pending. The chart above lists all of the basis for the motions. The number 1 reason cited for a motion to dismiss was that there was no physical loss or damage. The second cited reason was prohibition of access requirement for civil authority, and the third was the application of a virus exclusion. There have been 18 court rulings based on insurance companies' motion to dismiss. We're going to focus on the court's interpretation of the number 1 cited ground for dismissal, how the interpretation of the direct physical loss or damage that triggers business interruption coverage. So far, there have been a total of 12 business interruption cases stemming from the COVID-19 pandemic, which have been dismissed. 8 of those have been with prejudice and 4 without prejudice, and there's been 6 where the court ruled against the insurance company's motion to dismiss, allowing the claims to proceed. We're going to look first at those courts that have granted motions to dismiss with prejudice. In total, there are 8 cases. 3 of those have been at the state level, 5 have been at the federal level. There are 3 state courts that have ruled in favor of the insurance company, granting motions to dismiss with prejudice. Those states are Michigan, D.C., and California. The very first case in the country to rule on the direct physical loss or damage question was in our own state of Michigan, and Galver-Leidy's Management versus Michigan Insurance Company. The case was actually argued by Secrest Wardle's own executive partner, Henry Emmerich. In that case, Ingham County Circuit Court Judge Joyce Dragonchuk ruled that coverage required some tangible alteration to a property for business interruption to be triggered. In addition, while not necessarily ruling upon the virus exclusion, the court said that it would have barred coverage even if the claimants had alleged the virus did cause physical damage to the property. Like Michigan, the D.C. and California courts both ruled that actual physical damage or a distinct demonstrable physical alteration of the insured property was required in order to trigger coverage. Federal courts that have also granted insurance companies' motion to dismiss include Texas, Florida, Michigan, California, Illinois, and California. We're going to focus just on the Michigan case of Turek Enterprises versus State Farm Mutual Automobile Insurance Company, which was decided on September 3rd, 2020. United States District Court Judge Thomas Ludington of the Michigan Eastern District ruled that direct physical loss requires tangible damage and that loss of use was insufficient to trigger coverage. The court relied upon the Galverlides case and then also relied upon a Texas federal court decision that had been decided a few weeks earlier. That would be the Diesel Barbershop versus State Farm. In all of these cases, the courts found that physical damage was required in order to trigger business interruption coverage. Next, we look at courts that have granted the insurance company's motion to dismiss, but without prejudice. In these cases, we found that the rulings granting the dismissal were just as strong as those with prejudice. However, it's not clear why some courts chose to issue an order with prejudice and others chose to issue an order without prejudice. Certainly, this leaves rooms for complaints to be refiled. We have a total of 4 cases where federal courts have granted insurance companies' requests for dismissal without prejudice. 3 of those come from California. California case law requires that direct physical loss be established by a showing of distinct, demonstrable physical alteration. It also requires more than a loss of use of the property to trigger business interruption coverage. 1 federal court has granted insurance companies motion to dismiss without prejudice. That was in the case of Maloob LLC versus Greenwich Insurance Company, a ruling that was made on August 27, 2020. In the Maloob case, the court cited California law, which required tangible alteration of a building. The court held that the orders for closure did not render the business owner's restaurant uninhabitable or substantially unusable. Significantly, the Florida court relied upon a 11th Circuit Federal Appeals case, Mama Joe's versus Sparta. This was an unpublished opinion that had been released on August 18, 2020. In that case, the business sought business interruption coverage for damage resulting from construction dust. The appellate court held that cleaning of the construction dust was insufficient to constitute direct physical loss. The Florida federal court cited Mama Joe's case in its ruling and the Maloob decision. Next, we'll look at those rulings where courts have denied insurance companies' motion to dismiss. There have been a total of 6, 2 of them at a state level, 4 at a federal level. The 2 cases at a state level come from New Jersey and Pennsylvania. The New Jersey case, where the insurance company's motion to dismiss was denied, is the case of Optical Services USA versus Franklin Mutual Insurance Company. A ruling dated August 13, 2020 was issued. In that case, the court noted that New Jersey law allows direct physical loss to be established without requiring structural alteration. What was also interesting about the Optical Services case is that the policy at issue included the virus exclusion, but the insurer chose not to argue that as one of the bases for a motion to dismiss. Instead, they took the interesting position that the virus was not actually present at the insured property, but rather it was just the risk of the virus that had caused the business closures. Federal courts that have denied insurance companies' motion to dismiss stem from 2 states, that being Missouri and Florida. 3 federal decisions have come out of the Missouri courts, that being Studio 417 Inc. versus Cincinnati Insurance Company, KC Hops Limited versus Cincinnati Insurance Company Inc., and Blue Springs Dental Care versus Owners Insurance Company. The Studio 417 decision was first released on August 12, 2020. It was significant because it was the first ruling in favor of the policyholder. In Studio 417, the Western District of Missouri, the court denied Cincinnati Insurance motions to dismiss for failure to state a claim upon which relief could be granted. In that case, the plaintiffs were suing on an all-risk policy that did not have a virus exclusion. The court held that the plaintiffs adequately alleged a direct physical loss and a plausible claim for civil authority coverage. The court stated, quote, "Defendant's overarching argument is that the policies provide coverage only for income losses tied to physical damage to property, not for economic loss caused by governmental or other efforts to protect the public from disease. The same direct physical loss requirement applies to all coverages for the plaintiffs sue. However, in this case, the subject policy provides for accidental physical loss or accidental physical damage. The court noted that physical loss is not synonymous with physical damage. The term was not defined in the policy, so the court referred to dictionary definitions in supporting its position. The court commented on the Galvralides decision in a footnote, finding it distinguishable because in Galvralides, the plaintiff failed to establish the presence of the virus at its restaurants. Here, the court felt that the business owners had sufficiently alleged physical loss, and the court also found that it had sufficiently alleged that civil authority coverage applies based on the stay-at-home orders. The other federal court to deny insurers' motions to dismiss came from Florida. It's the most recent ruling of all the cases that have been decided to date. That is the case of Urogynecology Specialist of Florida versus Sentinel Insurance Company. The court in that case found that there was several ambiguous aspects of the policy which it decided made determination of coverage inappropriate. Nevertheless, the court did consider the policy's limited fungi, bacteria, and virus coverage and concluded that it was ambiguous. The court said the virus exclusion states that Sentinel will not pay for loss or damage caused directly or indirectly by the presence, growth, proliferation, spread, or any activity of fungi, wet rot, dry rot, bacteria, or virus. The court said the denial of coverage for losses stemming from COVID-19 did not logically align with the grouping of the virus exclusions with other pollutants, such that the policy necessarily anticipated and intended to deny coverage for these kinds of business losses. So based on reading the allegations in the light most favorable to the plaintiff, it found that the claims against Sentinel were plausible. So what can we glean from these rulings? Do they show or reveal any early trends? We think so. There are a number of states that we would categorize as being pro-insurer, meaning courts either at the state or federal level have sided with insurance companies on the COVID-19 business interruption cases, particularly as to what is required to trigger coverage. Those states include Michigan, California, Texas, Illinois, D.C., and Florida. But we're also finding states that reflect a pro-policyholder trend. Those states include Missouri, New Jersey, Pennsylvania, and Florida. The Missouri Federal Court has shown the strongest consistency in its rulings, having ruled 3 times against the insurance company in the months of August and September. If you notice that Florida was cited as being pro-insurance company, but also pro-policyholder, that was not an error. It's difficult to tell where Florida courts fall, as they have granted a motion to dismiss in the case of Mauricio Martinez versus Allied Insurance Company, and then denied a motion to dismiss in the Urogynecology Specialist of Florida versus Sentinel Insurance Company. Interestingly, both of these cases were heard by the same federal Florida court, and in both cases, the insurers had virus exclusions. In the Martinez decision, the court held that the virus exclusion applied. It stated that Martinez's damages resulted from COVID-19, which is clearly a virus. Neither the governor's executive order narrowing dental services to only emergency procedures, nor the disinfection of the dental office of the virus is a covered cause of loss under the plain language of the policy's exclusion. By contrast, we have the Urogynecology Specialist decision where the court held that the virus exclusion was ambiguous. What's significant to note, though, in all of these rulings where the court denied motions to dismiss, it is simply allowing the cases to proceed, not necessarily ruling on the merits of the case. In fact, returning to the business owner's first victory, the court in Studio 417 emphasized that the ruling means only that the business owners have presented enough facts to defeat the motion for dismissal and to move forward with discovery. The court added that discovery will shed light on the merits of plaintiffs' allegations, including the nature and extent of COVID-19 on their premises. In addition, the court said that its rulings were subject to further review following discovery, noting that subsequent case law in the COVID-19 context, construing similar insurance provisions and under similar facts, may be persuasive. Our key takeaways from tracking the COVID litigation is that federal courts seem to be more favorable to insurance companies. The denials of these motions to dismiss by courts does not necessarily establish the presence of a virus as constituting direct physical loss triggering the business interruption coverage. That the federal courts will still look to state insurance laws, which they're required to follow in diversity cases. Those state laws will vary considerably, but the specific policy language will be critical to any analysis in any proceeding. So what does the future hold? It remains uncertain. If you're keeping tab, right now there's 12 wins for the insurance company and 6 wins for the business owners. We'll continue to closely watch the legislative and legal developments in the COVID-19 business interruption coverage dispute. We hope that you'll join us for our next webinar in this series, which will be presented by Amanda Fatma. It will take place on Wednesday, October 14th, 2020 at noon. If you have any questions, here is my contact information. It includes my email address, which is sgriffin@secrestwardle.com. You can also contact me through social media, including LinkedIn. This podcast and others by Secrest Wardle's COVID-19 Task Force are available on our website. They can be downloaded at Google Play and Apple Podcast. Thank you again for joining me.